Recording in progress.
Chair Williams, we're ready to begin.
Okay. Welcome to this special meeting of the Planning Commission this Tuesday evening, November 8th, for the due process training. The regular Planning Commission meeting will start at 7 p.m. I now call this meeting to order. Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with justice for all. Okay, thank you. Ashley, please call the roll.
Yes. Chair Williams,
Present.
Vice Chair Ebnetter, here. Commissioner Nugent,
Present.
Commissioner Patel,
Present.
and Commissioner Wiggins.
Here. Okay. Good evening and welcome. We're excited to be here in person with options for virtual participation also. For those attending in person, complete a yellow request to speak slip and hand it to the clerk. If you're participating remotely, then you use the raise your hand feature in Zoom and you'll be called upon at the appropriate time. If calling in via phone, then press *9 to raise your hand, and when called upon, press *6 to unmute yourself. These options for public comment will remain available until I close the public comment period for that specific item. Note that the regular Planning Commission meeting commencing at 7 p.m. will include a general public comment item for non-agendized items. Okay. So with that, we'll move on to item number 1. The only item for this special meeting is the due process training and for the Planning Commission. Are there any speakers that want to address the commission on this item?
There are no speakers at this time.
Okay, great. So with that, I'll turn it over to the city attorney to present.
Okay, good evening. It's nice to be with all of you again. So this will be the same format as last time. I'm most likely going to take up the full hour. There's a lot to get through. I have about maybe a dozen slides. But this is also interactive. You know, I want you to, if you have a question, just interrupt me, raise your hand. It's completely fine. I want you to ask questions as they occur to you, because if it occurs to you, then it'll occur to other members of the commission as well, possibly. Okay, so with that, let's get started. Okay, so what does due process mean? It's kind of encapsulated there at the very top: no deprivation of life, liberty, or property without due process of law. So where does that come from? It primarily comes from the federal Constitution, and the 5th and 14th Amendments, having to do with protection against activity by the federal government and state governments, enacted at different times for various reasons, I'll say. And it also comes from the California Constitution as well. This is not going to be an academic discussion about, case law and how due process has evolved over the years. This is more of a nuts and bolts presentation about what do you need to do as the Planning Commission when you're acting in a quasi-judicial capacity. What do you need to do and not do, at a hearing when you're making a decision on a land use project? That's really the focus of the presentation. I will say, though, that there's a couple of kinds of due process. There's substantive and procedural. I'm going to talk about substantive due process for this slide and the next slide, or the slide after, and then we'll focus on procedural due process. So substantive due process means or refers to preventing unreasonable and arbitrary legislation. So it's kind of check on governmental power to ensure that laws that are passed, are not, again, arbitrary and have some reasonable basis. Our focus, though, tonight is procedural due process, which can be encapsulated as, it's really like notice, an opportunity to be heard before a neutral tribunal, and also making sure you have, again, notice of the hearing, ahead of time, not only for the applicant, but also for members of the public. So again, we have legislative acts on the one hand where procedural due process generally isn't required because, due process arises most typically when you have a liberty interest or a property interest that's at issue. That's when due process requirements can attach. And if you have a purely legislative act, then typically you don't have an individualized liberty interest or property interest, generally speaking. But again, the substantive due process principles will still apply. And again, for when you are acting in a quasi-judicial capacity, in a adjudicative capacity, meaning you are making a decision on a land use permit, then that's when procedural due process is required. And again, for legislative acts, just to round out that portion of the presentation, we're referring to ordinances, such as a zoning ordinance amendment, could be a text amendment, could be a map amendment, or some other change to the municipal code. Legislative acts also include amendments to the general plan, which have to be considered by the Planning Commission under state law and then go on to the City Council. And those are adopted by resolution. In addition to legislation, there are also requirements that arise by statute, namely the Brown Act. Has its own requirements, which I covered in the last presentation. And there are also public hearing requirements that may apply. For example, if you have a zoning text amendment, then that has its own public hearing requirements, as does a amendment to the general plan. And again, we're all still talking about legislative acts. Okay, now we're kind of getting to the meat of the presentation. So again, procedural due process is required when you're acting like a judge, like a court. You are making a decision on a land use permit. Might be on appeal, say from the zoning administrator, or you might be the hearing body in the first instance, and your decision could be subject to appeal to the City Council. But in any event, it involves, as you know, applying general rules, general policies to a particular situation, a particular piece of property. An applicant may be seeking different kinds of entitlements. Could be a use permit, could be a subdivision map, could be a design review permit, some other kind of special use permit, some grading related permit, for example. Variances, less typical, but also involves a permit application. In all those situations, you're acting as a decision maker. And again, we've talked about notice and hearing, and decisions will be ultimately based on findings. Okay, so for a hearing, it's important, it's critical, sometimes constitutionally required, or it could be required by statute, or both. It's important that the applicant receive notice of the hearing. Sounds obvious, it's their application, they need to know when is the hearing, what hearing body is it before, where is it? Obviously critical, but it's also required either by statute or constitutionally required so that their interest, they can explain what their interest is, why they want their permit, and what evidence they have in support of their application. Also for neighbors, most typically for a land use related permit, it's required either by state law or ordinance or both for neighbors within a certain radius to receive notice of it. Before those hearing requirements were in effect, just for historical reference, there is some case law referring to the constitutional right of property owners just to know what's happening, say the adjacent property next door. There was a case out of Ventura County in, I think, 1979. It had to do with a subdivision that was going into the property next door. It's called Horn versus Ventura County, for those keeping notes at home. But in any event, the basic idea was that, hey, if you're a property owner, you should be given notice about actions that are going to be taken that could affect your property interests. So you have a right to be told about those actions so that you can go and make your views heard. Now, I mean, it can be required more explicitly by statute, and it's very, very common. Again, you have the applicant will have an opportunity to present evidence, when they're seeking an application. So, and that's why applicants have their own special time, after the staff presentation, they get to present their case. Sometimes they have counsel that's on their team, sometimes not. But that's why they don't just get their 3 minutes. They get their own presentation time. Now, just on a related note, sometimes after the close of the public hearing and is brought back to the commission for deliberation, sometimes there might be discussion about, well, maybe you can add a condition that addresses some concern. Crucially important to give the applicant an opportunity to weigh in on that condition. It doesn't matter if the public hearing is closed. It's still their permit application. You need to give them a chance to explain whether a proposed condition is acceptable or not. So you can't foreclose, you can't prevent them from commenting on a proposed condition that can affect their project. Okay, and then again, as a matter of due process, applicants have a right to have their application heard before neutral and impartial decision makers. So I'll talk about bias in a little bit, but the bottom line is, if one of you are biased, then that may just mean that you may have to recuse yourself and step down from the dais and leave the room. Okay, so I was talking about evidence before. So the applicant provides their presentation. That's evidence. The staff report that's presented to you, that's also evidence. Public testimony, that's evidence. So you're looking at all of that. If you do a site visit, for example, important to state that on the record. That's evidence. If you meet with an applicant, which I'll get to in a little bit, but if you do, then it's also important to say that on the record. It has to do with something called ex parte contacts, which I'll talk about in a little bit. But all of those things together, that forms the basis of your decision and nothing else. So I want to discourage, for example, just going online and doing Google searches for, acceptable multifamily projects that fit into the character of the neighborhood. It's kind of an extreme example, but that's something you don't want to do because it might not be accurate, it might not be relevant. And also you want to give the applicant a chance to evaluate evidence that you may be relying upon in making a decision. And if you're just introducing that on your own at the hearing, then that can be problematic. So, if you have an interest in, say, certain types of evidence for certain types of projects, completely fine to communicate that to planning staff and say, hey, here's the kinds of things that I'm interested in learning about, as these types of projects are presented to the Planning Commission. No problem. It also needs to be tied to the findings, because the findings are the basis of a decision. So it can't just be, any old piece of information. It's got to be relevant. But if you ask ahead of time, then staff has a chance to vet that information, then it's put into a staff report. The applicant has a chance to review and digest that information. The applicant, by the way, will have reviewed draft conditions of approval too. So there's an opportunity for staff to just discuss kind of high-level concepts about it. Here's the kinds of evidence the kind of evidence that's going to be presented at the meeting. So, again, I think you're focusing on what's presented to you in writing and verbally. It's been vetted by staff. It's relevant to the decision. It's tied to the findings. So far, nobody's asked me any questions yet, so I'm just going to pause there and see if anyone wants to chime in.
You made the comment that if we are biased, we should step away from the dais, which, I mean, normally I think that would come out before we're here, before we're sitting here, but I guess
Yes.
you never know.
I'll get to that on the, let's see, I think in 2 slides.
And then I guess that's an interesting conversation. It's an interesting thing to think about because we all have biases, and I guess it's specific to a person. I guess I'm wondering, like, how do you narrow that down? Like, we all have biases about what we think is a good project or not a good project, or that it must be specifically.
Right. So I'll just kind of address it briefly now since you raised the question, then I can go over it in a little more detail later. So, there's certain kinds of conflicts of interest that are just kind of financial. For example, like if you own property within 500 feet of a particular project, then, 99 times out of 100, you're going to have to recuse yourself because you can't make decisions in which you have a financial interest. Decision could affect your property value, right? So apart from financial interest, there's a concept of, common law bias, where if you find yourself to be so, unable to be neutral and fair and kind of keep an open mind when you're faced with making a decision, then you might have to recuse yourself from participating in the conversation, or from participating in the deliberation. And as an example, I'll just address it now. So in one case, there was a planning commissioner, and that planning commissioner wrote an anonymous article in a newsletter saying how terrible a particular project was before it came to the planning commission. Then it came to the planning commissioner voted on the project, eventually it got appealed, and then once the applicant got wind of the fact that that planning commissioner wrote that anonymous article, they were not very happy about it. It got litigated, and the court said, okay, at some point, if there's some unacceptable probability of actual bias, like you can't be fair, in other words, then that can lead to a need to recuse yourself from the decision. It sounds like a really far-fetched example, but this is an actual case. It's called Nasha. It arose out of the city of Los Angeles. So just on a related note, it's important to also be careful what you say ahead of the hearing. We talked about social media last time. I'm just looking at you, Seema, just because you mentioned it last time. I'm not picking on you, maybe a little bit. But, it's just there's so many avenues now to, speak your mind, right? It's not just verbally or a telephone call or a letter or it's social media. It's like so many different platforms. Each of those is kind of an opportunity for a misstep. It's sort of a negative view of those platforms, but I just want to emphasize that it's important to be careful. If you, ahead of a hearing, if you say, I think this is a terrible project, I would never vote for it, you post that on your social media platform that's your favorite, that's a problem. Or if you say, this has to be approved, this fills a crucial need, I am going to vote for this project no matter what. It's kind of the other extreme, but it also presents the same problem. It indicates that, you're maybe biased one way or the other. I think, we're all people. You're all going to have sort of certain tendencies one way or the other. But I think it's important to just keep an open mind. If asked, you can say that you are going to keep an open mind, take in all the information, and make a decision at the meeting.
Can I ask a follow-up on that? It's very helpful. Just thinking through that scenario as a way to understand the concepts better. So if you were to make a statement in advance, I assume, and share it on social media, number one, that'd be a Brown Act issue.
Not in and of itself.
Okay, potentially if other commissioners saw it and liked it, right? That's,
If one other commissioner
yeah.
liked it,
Okay.
then that would be a Brown Act problem.
but separately, it would indicate that you, and I'm trying to think through this, make sure I understand it, the applicant did not get their due process. Is that what would be said? Because you evidently did not wait until the hearing to make a decision.
Right, so if your comment was, this is a terrible project, I'm not going to vote for it, before the hearing happens, that indicates that you're not keeping an open mind, that you're not being sort of fair and neutral. I mean, from the applicant's point of view, they may look at that post and say, come on, like, give me a fair chance, right?
And so just to hone in on it, is that an indication of bias and having bias is an issue with due process, or is it just simply that they did not get due process and bias is sort of the byproduct of them not, the way in which they did not get their due process? Does that make sense?
So taking a step back, procedural due process, again, think of it in a nutshell as notice, a hearing, an opportunity to be heard before a neutral decision-making body. So if you are biased before the hearing even occurs, then it could arguably deprive them of due process to be heard before a neutral hearing body.
Okay.
Does that make sense?
I think I'm seeing it, maybe it's 6 of one, half dozen of the other, but it sounds like it could work both ways. By laying out a decision that you've made in advance of the hearing, they didn't get due process because they didn't get their sort of fair shake. But it also is a way of indicating separately, or at the same time, that action indicates a bias in that you didn't wait to give them that fair hearing. So maybe it's the same thing, I'm saying 2 different ways, I don't know.
I would think of this maybe more simply as if you are biased, that can lead to a deprivation of due process for the applicant.
Okay, let me ask it one other way then. If you make a decision prior to the hearing and they're denied their due process, is that always bias?
Is it always biased to have made up your mind?
In advance, right?
You know, it's hard to speak in absolutes. I mean, you could be sort of leaning heavily one way or the other in advance of the hearing. But, you know, I think because, you know, the Planning Commission plays a crucially important role, right? You make a lot of decisions on projects. So even though you may be leaning strongly one way or the other, I would just strongly encourage you, and, you know, this is about due process, right? To just, you know, leave open a door, a window of opportunity to, you know, have your mind changed, right? Because you don't know, you know, what's exactly going to be presented at the hearing. So you may, if it's not a due process violation for you to be kind of leaning one way or the other in advance of the meeting. I mean, that's pretty typical, but I think just keeping an open mind and saying, okay, I'm leaning this way, but let's hear what the applicant has to say. Let's hear what the public has to say. Like that's an acceptable place to be.
Thank you.
Yeah, I mean, I'll just kind of add to that. Like, it seems natural that we're going to have some, you know, leaning, or because we all come prepared with comments, having gone through the packet, which is part of that due process, I guess. But, you know, we go through all the public comments that we receive in advance, and then we gain more information during the public hearing. But we have to do some preparation before we get here because there's a lot of information to cover.
Right. No, exactly. Oh, go ahead. Finish your thought.
Yeah. No, that's it. Just that's.
Yeah. No, I think as the Planning Commission, as planning commissioners, it's critical to just read the packet, right? Just be prepared, because then that way you can make an informed decision. So, and in so doing, in reading the packet, you're going to develop your own opinions. You're going to say, well, based on this information, based on, you know, the staff recommendation, I'm leaning this way or that way. That's completely normal. It's to be expected. It's fine. But I think, just keeping an open mind and just willing to hear everybody out, project proponents, opponents, you hear the staff presentation, and then it may just confirm where you're already leaning, in the direction in which you're already leaning, say, yeah, no, that's kind of what I thought. Here's my decision.
Last year, I had the opportunity to serve as a juror for a rather lengthy trial. And I think of the bias question very much as like selection of jurors to see if they could provide a fair trial. So if there's somebody that comes in with like, I hate everybody named Fred and the defendant's name is Fred, like they might choose to have that juror not be used when they do juror selection. That's kind of how I relate it in my mind. Is that what is basically we're trying to give a fair trial to the applicant?
I'd say it's the right idea, generally speaking, that, it's the criminal context. It's very different from land use decision-making.
Mm-hmm.
But it's the same very general idea that if there's going to be some decision that's going to impact you, you want to make sure that the decision makers are going to be fair and sort of give you a fair shake. Okay, maybe I'll move on to the next slide here. Okay. I'm going to take the last bullet point first, since I mentioned ex parte context before. So, when you have a decision that you're faced with, there's the applicant. So they're a party to the proceeding, right? Now, you can choose to not meet with the applicant, and that's completely fine. I've known planning commissioners and council members who have said, anything you want to say to me, you can say to me during the public hearing. Completely fine, no problem there. Almost like an encouraged practice. But it's also okay for applicants to meet with, planning commissioners or council members. But if you do, it's important to just disclose that, during the proceedings, after, perhaps at the beginning of the presentation at an appropriate time during the proceedings. If you have met with the applicant, just state it on the record, because then that way the public knows that you're basing your decision on the information that's in front of you, the staff report, the staff presentation, applicant presentation, and a meeting you had with the applicant to talk about the details of their project. If you're meeting, say if a matter is on appeal to you, and you have the applicant and maybe the appellant, maybe those are two different parties, then, important to disclose whether you've met with either party.
I have a question.
Yeah.
That's super clear. What about meeting with other people who are interested in the project? So if there's someone in your community who says, hey, I have an opinion about this and I want to talk to you about it before the planning commission meeting.
Right, so members of the public, so they're not a party to the proceeding. I've never taken the position that you have to disclose context with the members of the public. Like they're not the applicant, they're not an appellant. Like people are just going to walk up to you and like in the grocery store or wherever and say, hey, I heard about this project that's coming before the commission. What do you think about it? By the way, which is an opportunity to be careful and not say, I'm totally for or against the project. But those kinds of interactions, in my view, don't require like a disclosure on the record. Okay, I'm going to go to the first kind of two boxes on this slide, the gray one and the green one. So before we were talking about before the hearing, notice an opportunity, just being told about when and where the hearing is going to take place, and also the idea of a neutral hearing body. So at the hearing, it goes without saying, but it's important to pay attention, right? Just if somebody is speaking, if the applicant is speaking, just listen to them, look at them, and also make them feel like you're paying attention too, because those are two different things. It's actually paying attention during the proceedings, not kind of fiddling around on your phone, not sort of leaning over and having sort of extended conversations with, your fellow commissioners, not getting up and walking around, which I'm not suggesting any of you have done, but, just being present, focused, paying attention to the proceedings so that, because all of that is evidence. And it's important to just pay attention to all of that evidence. Things can happen quickly. People can, say something quickly, and you may say, well, wait a minute, say that again? What was that? Yeah, so it's important to be focused on, the person that's speaking to you. It sounds obvious, but it bears emphasizing. But also that, an applicant may say, I disagree with the Planning Commission's decision, or maybe an appellant, but at least I feel like I got a fair hearing, right? I mean, I think that's an important place to be, where you don't want a party to feel, you don't want a party to feel like not only that they didn't get a fair hearing for the commission, because sometimes, that can lead to kind of further developments, appeals, litigation too. So it's making people feel like they're heard is important in addition to actually listening. And also, I'll touch on this later, but again, it goes without saying, the applicant, just treating them with courtesy and respect is important. And also being public speakers too, treating them with courtesy, respect, because, for some public speakers, this will be the first time they'll be addressing the Planning Commission. They're not used to speaking in public. It's not, all of us are used to speaking in public. It comes kind of naturally. It doesn't come naturally for everybody. So it can be a difficult thing. And even when, or I'll say, especially when you may disagree with somebody, you can just being respectful, being courteous, making them feel like, they are heard, whether or not you agree with them, I think is important to convey. And, I mentioned sort of body language on the slide too. It's like if you're, anyway, I don't think I really need to explain what that means. If you're slouching, kind of looking down and covering your head, that doesn't necessarily make an applicant or participant sort of feel good about sort of whether you're paying attention to them. Again, not saying you did this, but bears emphasizing. Okay, so I was talking about phones before too. So important to just limit the use of electronic devices. So this is actually in the board and commission guidelines too. Accessing agenda materials using your laptop to look at the Planning Commission agenda, look at the plans, totally fine. That's why you don't have paper, because you have your device. Totally fine to look at it. If you got sick family member at home, you need to text them, that's okay. But I would just keep it limited. If you need to take some sort of urgent phone call, out of the room, maybe during a break in the proceedings. But this kind of speaks to making the applicant and those participating in the proceedings feel like you're paying attention. Because if you have your phone and you're kind of looking down like this, it can make people feel like you're not sort of present for the proceedings. So I already talked about bias, this test, the unacceptable probability of actual bias. So I don't think I need to repeat it, but except to say that if you feel like there's a question of bias, not because of a financial conflict, maybe someone on the applicant team. It's important to just look at the Planning Commission agenda, see who the applicant is. And then the minute you notice, hey, I know the architect on that team, I should call staff, Nira, me, Mazrin, whoever, say, is this a bias issue or not? And, we'll have to talk through it and figure out, how do you know them? What are the facts? So early notification works well for kind of working through that analysis. Is it a bias issue or not? And we may end up concluding it's not really a bias issue, but tell the applicant, get it out on the record, say, hey, I know somebody on the applicant team, I can still be fair and neutral, putting it out there just so everyone's aware of it. It can lead to that sort of conversation, but letting us know as early as possible, whether it's a financial conflict, source of income, gifts, you own property, you own real property nearby or have a leasehold interest, those kinds of conflict issues, better to have had that discussion early, not at the Planning Commission meeting.
I have two questions, one related to this slide and one to spark something. It says evidence of personal bias, and I asked you this in my training, I think, when I started, but I tend to have in my mind the idea of the appearance of bias, and that's my standard, typically, just operating procedure is avoiding the appearance, but you've used the word evidence of personal bias versus appearance of personal bias here, so I wanted to ask if there was a technical legal meaning or importance to that word, evidence in this case.
So for evidence of personal bias, that's tied to the test that's on the screen. Is there evidence that leads to an unacceptable probability of actual bias? And these aren't bright line tests. It's all very fact specific. We have to understand what are the facts. Do we think that meets that legal standard or not? I'm not talking about necessarily the appearance of bias, but the appearance of bias is also something you want to avoid too, because you want to, again, instill confidence in the applicant, members of the public, that you're a fair and open-minded, neutral planning commissioner. So you even though you may not have a technical legal conflict of interest, if you think maybe there's an appearance of bias, and maybe that may lead you to, consider recusal because of that appearance. I mean, I think there's a bit of tension wrapped up in there, because on the one hand, your job as a planning commissioner is to make decisions. So it's important to not just say in every decision, oh, I think I might be biased, and get out of making a decision. So it's more fact-based, but they are two different things. Meeting the legal standard for common law bias is indicated on the screen, and avoiding the appearance of bias.
Very helpful, thanks. And for my unrelated question, we're talking about the hearing requirements. Will you, not to take you off topic, but the noticing requirements, will you get to the distinction between a due process noticing requirement and a Brown Act noticing requirement?
I'm sure. So due process noticing requirements I kind of addressed before. It's the idea that as an applicant, you have to be told, when and where is the hearing, have an opportunity to be heard, all of that. And also maybe you're a neighbor. Maybe you have a project could affect your property interests. In addition, maybe there are statutory requirements that require notice to you as a neighbor of a particular project. So that there's kind of all of that to consider. I don't know if I've answered your question yet or not.
Sorry, I guess I was remembering, and I hope I'm not incorrectly remembering, that there's certain noticing requirements stemming from the Brown Act.
Oh, yes. Well, no, of course, like separate and apart from, say, a public hearing notice for a use permit, some sort of land use permit. Then the Brown Act has its own general requirements for noticing meetings of the Planning Commission, like this one. So in this case, there's no public hearing that's happening, right? There's no land use decision that's happening. It's a training. But under the Brown Act, if the Planning Commission is going to be discussing something within its jurisdiction, like how to comply with due process requirements, that has to be noticed as a public meeting so members of the public can participate if they want to. So that is separate. It's completely separate from a due process noticing requirement.
Very helpful, thank you.
Okay, so this is from our handy rules and procedures for boards and commissions that was updated recently. So this is pretty much verbatim. Now, at the very top, it says, put community interests first at all times in decision-making. Now, these are commissioner guidelines, right? I mean, there are some caveats. For example, Maybe there's some community interest in, say, denying a project. Maybe the project is subject to the Housing Accountability Act. So, you know, if these guidelines are not superior to state law, right? These are sort of guiding principles for the Planning Commission. But it's also important because they guide not only the Planning Commission, but all of our other boards and commissions as well. In the green box there, sort of reemphasizing keeping the community interest in mind, avoiding representing your personal interests. As a planning commissioner, you're not representing yourself. You're a planning commissioner. You're representing the city interests as a whole. And again, just treating applicants, participants, the public, staff, and each other, you know, with respect and courtesy, I think is crucially important for smooth decision-making, for effective decision-making of the Planning Commission. Again, in the blue box, you know, encouraging diverse viewpoints, that's great, but also just be aware that encouraging diverse viewpoints to the point where you're having an extremely prolonged discussion about a topic, you know, that's a balance. You know, all of you have different viewpoints or overlapping viewpoints, and that's completely fine. But, you know, if you're continually, say, having a back and forth on a particular issue, you go back and forth and back and forth and back and forth, that's not productive, right? I think it's important to kind of keep your eyes on what's the ultimate goal of the hearing, to make a decision one way or the other, legally defensible based on the findings, right? Also, on the very last bullet point, again, this is from the Commission, Board and Commission Rules and Procedures, keep it clear and concise and on topic, because if it's kind of a muddled presentation, and sometimes you need to talk through things, and that's okay. But if it gets so muddled as to be unclear to the applicant as to what you're saying, then the applicant may want to be responsive, but they may not know what they need to do. So it's important to be clear. It's also important to be concise, because if you speak for so long on something that you start to lose other commissioners or the public, then it leads to less effective decision-making for the Planning Commission. So it's important to be kind of aware about, you know, how clear you're being, how concise you're being, because other commissioners may want to respond to you, right? This is getting a little bit away from sort of due process per se. It's more about effective decision-making, but they kind of work hand in glove. I'm going to move on to the next slide, though. Okay, so for decisions, we're kind of getting towards the end here. It's important that the record is clear. So if in the end there's some litigation over a land use decision, say made, maybe it's appealed to council, maybe it gets litigated, what is the record? Like there's no depositions. It's based on what's called the administrative record. It's the staff report. It's the staff presentation, the applicant presentation, all the materials presented to you, the conditions, project data table, the CEQA document, you know, all of that information, the testimony of the hearing, the deliberations, all of that is part of the administrative record. So your decision should be based on a clear record. And so that includes clear standards, could be in the zoning code or state law or some combination, and clear factual evidence so that a reviewing body, could be a court, can kind of piece it together and figure out what did the city decide? How did it make that decision? And that's where the findings come in, because the decision is supported by findings. Findings are supported by facts. And that's where a resolution kind of ties that all together. And that's also where we come in as staff, to make sure it's clear, make sure it reflects the commission's decision, to make sure it's also legally defensible. Also bears emphasizing that your decision needs to be guided by appropriate factors that are relevant to the decision. So if you're looking at a design review permit, you're looking at design issues. You're not looking at non-design issues. Like, for example, what would be a non-design issue? Like looking at so Manira mentioned like the use of the property. So that's not the use is going to be governed by the general plan and most typically zoning. A design is design. It's, it's architecture, materials, all these other things that don't relate to, for example, use, height, setbacks, other factors. So just, again, important to focus on, what is this decision before you, and to focus your discussion on those findings, those facts that are relevant to that decision and the scope of that decision. Okay. Then lastly, this is something that I touched on just a moment ago, but a court will look at in seeing whether the city's action is defensible in the land use context. Was there an abuse of discretion? So that can occur if the city didn't proceed in the manner required by law. Maybe if a city didn't provide adequate notice, for example, it short-circuited maybe a review period for a CEQA document, for example, or the decision is not supported by the findings, or the findings aren't supported by the evidence. So again, that's why it's important to make sure all of those pieces line up so that you have a clear decision based on clear findings, based on evidence that's in the record that's been presented to you. And just the first part of that gray box, the fair hearing, again, is crucially important, because if there was inadequate notice, if the hearing was unfair, if decision makers are not impartial, if they're biased, then a fair hearing may have been denied. Again, it's all fact-based, but these are all principles to be aware of as you go through your decision-making process. And that's it.
Could you go back one? I'm just trying to think through the difference between you've got this fair hearing and abuse of discretion. Are they two separate standards of review, or are they potentially, I suppose, overlapping?
There's a, if you think first of it, if you think about it chronologically, first there's the hearing before the Planning Commission, and then you want to make sure that a fair hearing occurs for the reasons indicated on the slide. Maybe it goes up on appeal, and then a court will look at it, and if there was an abuse of discretion, a court may overturn the city's decision. If there was an unfair hearing, that could also be a basis for overturning a city's decision. I've referred to the Nasha case before, where there was a biased decision maker. So in that situation, it was problematic for the planning commissioner to have made up their mind ahead of time. There was a host of other reasons too. There were a poor set of facts, but these are different things to consider. The abuse of discretion can be a reason for a decision to be overturned, and also as a matter of due process, if you don't have a fair hearing, that can also be a separate grounds potentially.
Thank you.
Through the chair. Thank you for your presentation. So these are rules rules and procedures for boards and commissions. Are there separate rules for elected council members?
I think, really these principles also apply to elected officials as well, like due process principles, constitutionally required due process principles, notice a hearing, before a neutral tribunal, that also applies. Say if a decision is appealed to the city council, same principles apply.
Perfect, thank you. So as it pertains to biases, I kind of look at it somewhat. We are a quasi-elected commission because we're appointed by an elected council.
Well, you're an appointed commission.
Appointed,
You're
right.
not quasi-elected, you're an appointed
Appointed,
commission.
Right. It was explained to me prior that we are on almost quasi-elected because we've been appointed, but that's neither here nor there. That was the last attorney in your position. But, so what I was thinking about with the biases, though, is that, if it's known that a certain commissioner or council member or board member might be part of a group, say YIMBY or NIMBY or Social Equity Group, NAACP, Sierra Club, those are known entities that have goals in mind what they want to accomplish. So would that automatically imply that a commissioner might have biases in a certain manner?
Yeah, that's a really interesting question. So I would say it doesn't automatically, imply bias or recusal. I think you have to look at the facts. So I think the more organizations, one is a part of, and if those organizations take positions, general positions, won't necessarily result in some determination of that person is biased. But if they are part of, say, organizations that then take a position on a particular project, then that could be problematic. Again, it's very fact-based, so I can only sort of answer very generally, but it could potentially be problematic for anybody, whether it's council, planning commissioner, anyone in a decision-making capacity, to be part of an organization that has taken a position on a project that is then coming before them.
So my other part of that, which I did not ask, was most of those types of organizations base their decision how they interpret state law. That's the only way that they're going to be able to come with an argument against or for the most part. So when I, in the past, was looking at a project and I wasn't sure if there was legal standing on what my decisions were based on, I would ask the city attorney for their input, and it was very helpful numerous times. So it seemed like it as long as you're following the law, obviously, you can make the statements that you want to present.
Are you, so let me kind of reframe what you said. So I think those who are participants in a proceeding, maybe they're advocates for or against the project, they're going to send communications to the Planning Commission and City Council. It happens all the time. I mean, it's really part of petitioning your government, right? So some individuals or organizations may say things that are incorrect, that are a misinterpretation of the law. They can say what they want, but then if and you're considering all these materials as they are presented to you, if you have some question about, is that interpretation of the law correct? Then, absolutely, you can contact staff and say, what do you think about this? And you may want someone on staff, whether it's me, assistant city attorney, planning manager, somebody else, to say, hey, we've gotten these communications about some particular state law. Can you clarify what the law actually is? And then that can get everybody on the same page.
I have a related question. What about, belonging to the AIA, the American Institute of Architects, and in additionally having, other chapter members contact me with their thoughts on a project? What are your thoughts about that?
I mean, again, it's all fact-based. I mean, being a member of a professional organization doesn't necessarily imply bias in and of itself. I mean, if the AIA took a position on a project that was coming before the Planning Commission, seems kind of unlikely, but so, if it did, then that could be problematic, but, it's a pretty big organization, so just being part of that organization alone, and if they take very general positions on what kinds of architecture they like to see, I'm just kind of,
They
fashioning
sometimes
this.
take specific, though.
Yeah, I mean, if you have let me just answer it this way, since we're running short on time. If you have a concern about a potential bias question, just ask us. And just ask me, ask staff, and say, hey, here's the position that this organization I'm a part of. Here's the position that they've taken. I'm wondering whether that position is somehow imputed to me because I'm a member of that organization. I don't want to give the appearance of bias. Well, then, let's talk through that and then find out whether or not that's truly a bias issue or not.
Okay, thank you.
Similar question. I was going to say, I did ask you once, and it was, I'm a member of many organizations, pick your favorite, Sierra Club, NRDC, Silicon Valley Bicycle Coalition. And I had reached out with a question about one of the nonprofits I'm a member of wanted me to host a holiday party. And the guidance I had gotten at the time was, if you're a member of the organization, that is taking positions, as long as you are not participating in the meetings or participating in the discussions or in the decisions where they're taking positions, then it's generally okay. Many of these organizations have like 10,000 members, right? So I've been really careful to make sure that I don't join meetings, I don't join discussions, I don't vote on things for all of these organizations I'm a part of when they're taking positions.
Yeah, I mean, I think that's the that's the bare minimum that you would want to do. I mean, certainly it's cleaner to just not be part of those organizations at all. But, I understand that there's kind of a balance to strike too. For national organizations like that, I mean, maybe it depends on the project, it depends on the issue. But it could potentially be less problematic. Whereas if you have a very local organization that is constantly taking positions on matters that come before the Planning Commission, that type of situation sort of lends itself to recommending just not to be part of that organization at all, just to make it cleaner from a perception point of view. We have a few minutes left. I don't know if there are any other questions.
Through the chair, just a quick comment. The discussion reminded me early on in my process here as a planning commissioner that I would come to meetings quite often thinking I knew what my stance was going to be. And as soon as I realized that in a couple of meetings I needed to change my mind, it was quite eye-opening and a lot better. It was a great way to learn not to be biased, and it really sucked.
Yeah. No, I think coming in with an open mind is definitely important. But okay, if there's no other questions, we have 2 minutes to go. I think we need a few minutes to change around. So when should we return?
And do we want to take a break now? Okay, we would like to take a quick break. Oh, yes. With that, we'll adjourn this meeting. Thank you.
Public comment?
I'm sorry?
Public comments?
Oh, are there public comments? Yeah, I thought we did before the presentation, I guess. Okay, so if there's no further questions or comments, we can adjourn this meeting. Thank you.